Alright guys, we're back. Sorry, I was just helping somebody schedule for the state exam, so it took me a little bit longer, but it's now done. We're going to talk about wills. You guys know what a... hey, make sure your cameras are on, please. You guys know what a will is, right? Who can tell me what a will is? Let me know in the chat. What is a will? In the chat, like, let me know what is a will. Thank you. Oh, Elda's camera is working. All right, Elda. Good. Okay. Will. A document that states who gets what and where the money then it goes to. Who gets what and what. A document stating what you've done with your assets. As far as what? A written document that distributes to whoever you leave it to. As far as what? Legal document. Great. For what? A will is something you leave after you die. Okay, so the will is something you leave when you're alive, right? And after you die, it says what you leave to other people or entities. Correct. So getting better. So if you guys understand what a will is, it's your last will and testament. What does that mean? Simply, if I die tonight, right? It's not what we're planning. We're planning to live 200 or 300 years. Got it. But if I die tonight, this is my last will and testament. These are the assets that I hold. So these properties, being a real property, personal property, whatever, the cash that you have, whatever, right? This is what I have. If I die tonight, everything I have goes to X person, Y person, Z company, whatever you want. You determine who gets what in terms of assets that you hold while alive, and when you die, what goes to them. All right, so that's what a will is. And there's different types of will, validity, and we need to understand the process that goes with it, because when you die, the heirs don't inherit everything right away. It has to go through probate, which is a court proceeding that says, wait a minute, you're supposed to receive $1 million, but there's like $995,000 worth of debt that needs to be paid. So creditors need to get paid first before you inherit. You guys understand? So probate will determine who gets what from those assets. Okay? All right. Next. Make sure, please, make sure your cameras are on. Very important, so it counts your hours. So a will, I just explained to you guys, a will is the last will and testament. It is the legal instrument that voluntarily transfers real and personal property after the owner's death. Okay. It describes how the maker of the will, called the testator, the person creating the testament, or devisor, wants the property to be distributed. A beneficiary of a will is called either an heir or devisee, and the property transferred by will is known as a devise, while property transferred by lease is known as a demise. Write this down. Property transferred by will is a devise. Property transferred by lease is a demise. Damn it. All right. Property transferred by lease is a demise. All right. You need to remember this. We'll address it again later on. A will generally takes one of the following forms. So there's different types of wills. It could be a witnessed will, and obviously, as the name says, it's in writing and witnessed by two people. It could be a holographic will, right? Holographic means hollows, been myself, and graphic, it's handwritten. So it's the testators that handwrites dates and signs. So I don't need to have witnesses for a will to be valid. In certain states, it really does not matter. Okay. Approved, that means it's on a pre-printed forms that meets the requirements of the state law. So some states you need to have it on an approved form, state form. Not all the states have it. Getting some background music here. Non-cupative means made orally, written down by witness, generally not valid for the transfer of real property. Okay? State law establishes requirements for a valid will, and the law generally requires that you are of legal age and mentally competent. It requires that the testator indicates that the will is the last will and testament, that the will be signed, and completion of the will be witnessed and signed by witnesses, and that a will is completed voluntarily without duress or coercion. So very similar to contracts. It's a contract. The will is a contract, right? There's an offer, and there's either an acceptance or a rejection, right? There has to be a meeting of the minds or mutual agreement. Look, I can leave everything to my kids, but my kids can say, I don't want this, right? Like I've told my dad the same thing. I don't want the inheritance. I prefer to have you. If I don't have you, then I don't want anything else. It doesn't matter. Let the other, my sisters and my brother get it. I really don't care. So I'm entitled to reject the inheritance. Does that make sense? So a will is a contract. Legally competent parties, we just went over this, legal age, legally competent parties. There must be a granting clause. So this is my last will and testament. This is what's going to be transferred to potential party, right? There has to be some type of consideration. I would not transfer to somebody just because there's love and affection, and legal purpose. Okay, I cannot pass along my drug empire, right? Unless it's Pfizer, but I cannot pass along the drug empire because that would be illegal. So voluntarily, without duress or coercion, similar to a contract. Okay. Now, a court proceeding called probate generally settles a decedent's estate. So we go to court, as I said earlier, to figure out what happens to the assets. So whether the person has died testate, that means testate means you left a valid will, so you have a will, testate, testament, or you died intestate means not having a will. Testate, you have one. Intestate means no will. So whether you have it or not, real property may be exempted from probate if it's held in land trust. So we'll talk about that at a different time. Probate of real property occurs under jurisdiction of the courts in the state where the property is located, regardless of where the deceased resided. So this statement is very powerful for a reason. It's for you guys to understand the power of a will. if you died without a will, the property is going to be handled based on the jurisdiction. So if I have a property in Texas, I have property in California, property in Pennsylvania, and a few properties here in New Jersey as an example, and I die without a will, my kids are going to have to go to each state to figure out what they get or not. Okay? A will says all these properties located at A, B, C, D, or E location, right, will be handled in the following way or distributed in the following way. So a will is so important. So important because it reduces the amount of work that you have to do after, right? And when I say you, it's your heirs have to do after. Okay? The probate court's objectives are to validate a will if one exists. So it's for the court to say, okay, there's a valid will, so this is what we're doing. Good. Identify and settle all the claims. Like I said, outstanding debts must be paid. So if there's any claims, the debts must be paid, or any other claim there might be. Distribute the remainder of the estate to the rightful heirs if the will does not name an executor. And the court will appoint an administrator to fill out this role. So the probate court is going to say, is there a will? Yes or no? There's a will, then what does the will say? Then there's an executor to execute my last will and testament, right? My last will, what I wanted to happen, okay? If there's no will, then the court appoints an administrator to figure out, based on descent and distribution laws in that particular state, who gets what in the transaction. Before transferring to those parties that are entitled to the inheritance, they're going to figure out again any outstanding debts or any other claims against the property. Okay? So here we go. Transfer of a debts estate by probate. There's distribution by probate. If you died testate, you have heirs, right? So first creditors get paid. Then there's a legal life estate. For instance, if there's a husband and wife, whoever died, the deceased spouse, the other party acquires right away. If there's no deceased, there's no surviving spouse, then it goes to the heirs by will. If you died intestate, means without having a will, but you have heirs, again, who gets paid first? If there's any claims to be paid, creditors. Who does it go to after? Again, legal life estate, the same thing. And then, because you have no will, it goes distributed by descent. So it's the laws of the state. And if you died intestate with no heirs, so no will, no heirs, creditors get paid. And then it goes to the state where you reside, or where the property is located, I'm sorry, by escheat. So if there's no heirs, who gets it? The state does. And then they sell it at an auction, and then they keep the money. Simple as that. So, if you have no heirs, right here, guys. If you have no heirs, still prepare a will. Okay? Put my name on it. Don't give it to the state. Give it to me. I have a lot better things I can do with that money. Just saying. All right? The point is, if you don't have heirs, or you don't want to leave it, you don't have to leave it to your heirs. You don't have, like, the kids can be disinherited. My kids can get nothing, right? I already told them, misbehave, you see what's going to happen. I'll die of a heart attack after this, but you get nothing. Simple. You can name a nonprofit. You can name. You want to give the money to a school. You want to give the money to a church. You want to give the money to a friend. It doesn't have to go to the direct heirs. It doesn't have to go to your kids. It doesn't have to go to the spouse. Depending on state laws, they're entitled to something. But you can do whatever you want with the money. But why give it to the state? Why letting it go? Okay? Does that make sense? If you have no heirs, I volunteer to be one. Same. Your contribution is greatly appreciated. All right. You can always give it to your pets. Yep. You guys know those stories? Millions of dollars to a dog and millions of dollars to a cat. and then there's somebody appointed and getting paid by the estate to make sure that the cat or the dog, whoever was in the scenario, make sure they have a good life until they die for the final 2 or 3 years of their life. Here's millions of dollars. Make sure they have everything, whatever the dog wants. Okay, crazy, right? Here we are struggling for a penny, and the dogs and cats getting millions. Anyway. All right. Next. When the pet dies, what happens? Benjamin is asking. It depends. Whatever. See, these were based on the will. So the will might say, while the pet's alive, the assets belong to the pet, and the legal guardian has X amount of dollars that they'll receive a month for maintaining the pet's needs. After the death of the pet, which is the beneficiary of the will, then there's contingency beneficiaries. So if the pet dies, who gets the assets, right? And that's how you should prepare a will. Like, if I die, then everything goes to my kids. If one of the kids, for any reason, dies, then his shares is distributed to the other kids automatically. It's whatever I decide. Or his share can go to a non-for-profit. So we determine what's called contingency beneficiaries. Simple. What happens after the pet dies? I don't know, whatever the will was. Okay, so whoever the legal guardian is of these pets, make sure to keep them alive for a very long time. Put them in the freezer if they have to. You know, cryogenic, that's what it is. Keep them there, they're alive. Don't try it at home, okay? It's a joke. All right, testate proceeding, guys, we already talked about this. It's when you die with a will. Again, they'll first find the creditors, they determine the validity of the claims, and then they distribute the assets accordingly. Intestate, the state decides who gets what. Okay. Next, we have involuntary title transfer. You guys remember this word? Alienation? Okay, great. So, title transfer is alienation, is when you are bringing a foreigner to the property and transferring the title to that foreigner, which will now become a citizen, let's say, of the property. Okay? So, involuntary title transfer, that means you are being forced to transfer the title, or a forced alienation. Okay? In that sense, we have the laws of descent, meaning the government decides how it's distributed. It's not up to you. It's involuntary. If it's voluntary, you prepare the will. Involuntary, government decides. Abandonment, so adverse possession, as you guys know. Foreclosure, you fail to pay the debts that were against the property, like the mortgage, and they foreclose. Eminent domain, government takes over. And adverse possession, again, like abandonment claim and estoppel. So, laws of descent. Again, in green, because it's important. Involuntary alienation occurs when title holder dies without a valid will. Abandoned. The property has been abandoned for a statutory period, so it may also escheat to the state or county. Foreclosure, you fail to pay. Eminent domain, we already talked about this as well. Let's talk again about adverse possession. Adverse, whatever you guys want to say it, that's fine. But adverse possession is an abandonment claim as well. Is where somebody finds your property vacant or unoccupied, right, and takes over. To claim legal title, the adverse possessor must be able to show the claim of right or color of title as a reason for possession. Meaning you're not breaking and entering. You did everything proper to get into the property and use the property. So there has to be a notorious possession, okay? Open, visible, notorious. It has to be a constant hostile possession, meaning never had permission, but you're there, okay? You must occupy the property continuously for a statutory period of time. So state of New Jersey, 20 years, Florida, 6 years, and so on. And in some states, not all, in case that question was coming, in some states, not all, you must pay taxes. So in Texas, that's one of the states where you have to pay taxes in order to claim adverse possession. In the state of New Jersey, it does not matter. Somebody got to pay. It doesn't have to be you. Claim of right is based on the adverse possessors occupying and maintaining the property as if he or she was the legal owner. Color of title results in the grantee when the grantee has obtained a defective title or received title by defective means, but occupies the property as if he or she is the legal owner. So, two ways that you can own property. The court may hold that claim of right or a claim of color title is a valid reason for possession. Notorious, open, visible, notorious possession or hostile possession gives constructive notice to the public. So by people seeing you there and using the property, they know that you're there. It's very important. You guys remember actual notice and constructive notice? Actual notice is your neighbor knowing you're actually trying to take over that property. Constructive notice is they see you're there. They don't know what it is, but they don't inquire about it. So they see you're there. Nina, this is what we're talking about. Squatters. Adverse possession. Squatters' rights. Yep. So it's easement by prescription. Squatters' rights or adverse possession means the same. It is possible for such notice to prevail over notice by recordation as the dominant evidence of legal ownership, provided that the possessor has occupied the property continuously for a statutory period of time. So this is when I was asking, if you find a $100 bill on the floor, what are you going to do? Right? If you put it in your pocket right away, right? Maybe you did something kind of like, oh, that's not ethical. That's not the right moral standards. But if you held on to the money and waited a little bit longer to see if anybody was going to show up and claim it, right? And nobody did, and you walked away with the money, then that's adverse possession. Same thing. You got it? It's hostile. It was not your money. It was open, visible, and notorious when you picked it up and stayed there and nobody claimed it. You guys see what I'm getting at? So adverse possession is taking over a property, right? And everybody must see what's happening, even though they might not understand. So actual notice, you told the neighbor, hey, I'm taking over the property. Constructive notice, you're just there, using it, maintaining, and hey, neighbor, how are you? You guys got it? No questions. That's what it is. Avoiding adverse possession. Can the owner... All right. Everybody saw that pop up on your screen, right? That question? All right, let's go to the question. Don't tell me you're a nerd too, right? Are you? I would understand that. I would ask that question, like, hey, should I change professions? So, yeah, you have to understand what adverse possession is. It doesn't matter if you're a drug dealer or if you could be the mailman. You just find a vacant property and take over. But the thing about adverse possession is they have to follow a certain process, and each state has their own rules for adverse possession. So it doesn't matter what they are, what kind of business they handle. If they're handling that business inside the house, then it's for illegal purposes. So no, they don't get that claim if they're doing it inside the house. If they happen to be drug dealers who saw a property, but they're living there, maintaining it, no drug dealing in the property, then they have the same right. Okay? Just keep it as an outside business. That's all. Good question. Some people here are like, oh, shucks. I thought I had the new location. All right. So it's a joke, okay? Don't take it serious. So how can the owner prevent this from happening? How can the owner prevent this from happening? Well, periodically inspecting the property. That's one of the things. Okay, show up and say, hey, who are you? Get out. Or say, hey, who are you? All right, thank you for maintaining my property. Would you like to continue? So there's two things that must happen. Either I specifically allow you or specifically kick you out. If I just show up, see that there's somebody there, and I don't address it, then I'm not stopping the claim. You guys understand? It's very similar to if I have a fence. I think I mentioned this to you guys, right? If I have a fence and I replace the fence and I move 1 foot over, the neighbor saw it. But if the neighbor does not complain and say, hey, Bruno, that fence, it's on my property line. If the neighbor does not complain after 20 years, in Jersey, after 20 years, I can claim the property. So just by watching and not taking action does not stop the period of time that you have to go through, okay? So very, very important. Estoppel, it's not highlighted. There's not questions in the state exam that I remember. But estoppel prevents a person from claiming a right or interest that is inconsistent with a person's previous statements or acts. As a basis for involuntary alienation, the doctrine of estoppel can prevent an owner from reclaiming the property. So for instance, it was sold or transferred under false pretenses. The owner conveyed the property with issues on the title. I'll give you the example. I sold the property, right? But I'm not the rightful owner. There's a defect there, right there. Can I go to you and say, hey, oh, give the property back? No. You guys understand? So I'm stopped from any further action. I gave the property to you, whether it was correct or incorrect, I should have done or not done, it's done. So the grantor is fully aware of the defect, but makes no disclosure to grantee. The grantor later cures the defect and then claims to be the rightful owner of the property on the basis of effort and expense of clearing the title. The estoppel disallows the grantor's claim because the prior conveyance action. Okay, so the grantee remains the legal owner and benefits from the clear title as well. Make sense? So pretty much, I sold to you, it stops my claim. I sold to you, it stops my claim on the property. I cannot go and say, hey, give it back to me. No, sold. All right. Estoppel certificates, when it comes to mortgages, it's the same thing. When the bank transfers the debt to another bank, the first bank is stopped. They cannot go after any more monies from that day on. A collection company, same thing. When it's sold, transferred, and so on, that's the balance due. That's how much you can claim. No more than that if it transfers to somebody else. Or if you sell a discount to somebody else, that's your problem. Okay, it stops right there, your claim. Felix, when you periodically check on your property to avoid adverse possession, do you need any proof that shows you've been checking the property? It's what I was telling you before. Just checking the property doesn't resolve the issue. You either specifically allow or specifically reject and kick them out. You have to be specific about it. You have to let them know, hey, Felix, get out. I don't want you here. All right, so you have to be very specific about your action. If you just pass by and see, oh, Felix is there, and you keep on walking, no, it did not stop the adverse possession. Felix, you're still taking over. That's what it is. Okay? All right, next, title records. So now we're going into closings and we're going into recording into public records. There's something called a chain of title. And the chain of title is the most important thing when it comes to recording. Did you guys hear the sirens? I tried to adjust the mic so it doesn't, when I stop speaking, it just shuts off so you don't hear the sirens on it, but I think sometimes it still comes through. Anyway, so chain of title. Like I said, it's the most important thing when it comes to recording title or understanding who owns what. Hold on, there's one more question. So Felix is asking, so how about in the case where you've been checking it, but it happens that you never saw anyone, but you later find out someone has possessed the property adversely? All right, so if you've been checking periodically in state of New Jersey once every 20 years, right? Or more if you can do more, but at least once every 20 years. They don't have rights to the property until they claim it. So you always have a chance, until they claim it, you always have a chance to stop it or allow it. If it's been 20 years or more, now they have a chance to claim it. Going back to adverse possession. They have a chance to claim the property. You have to stop and by then. If they don't do anything for 30 years, right, they still don't have the right. They have to claim the right. I've been here for 20 years. I've been here for 30 years, whatever. They have to specifically claim the right as well. And that's a court action. As an owner, you should periodically check. If there's nobody there, then you're good. Because it has to be visible, open, and notorious. That claim must show that they've been there. You got it? So every time you go check, let's say every 3 years you check the property or send somebody to check the property. Like, I got property in Texas. I don't go to Texas. I send somebody there, local, to check the property and let me know, hey, Bruno, everything looks great. You understand? So I don't have to go there. I'll find somebody to go and give me a report about it. Simple. All right? So it has to be, again, specific, go as many times as you can. It's not the passing by that will stop it or allow it. So back to this, chain. I told you that is the most important thing when it comes to recording, because for me to know who the owner is, or who's the rightful owner, right, I need to see who was the previous owner, and if that transfer from the previous owner came to the current owner. Simple. I sold to Nidia, Nidia sold to Nina, Nina sold to Fallon, and that's how it goes. These transfers that I just mentioned right now must show in public records that say from Bruno to Nina, and then the period of time that Nina had it until she sold it, it went to Nina, okay, and then so on to Fallon, and so on. So he has to show the links, all right, and he has to show specific dates. So these are the period of time that it was owned by a particular party. So here was John, here was Mary, here was Adam, Verona, and then he went to this guy Chris, and this guy Chris sold to Bruno, to me. But look, the previous owner of record was Verona here. Previous owner of record. So because Chris's deed is now recorded here, there's something called a gap in the chain. If there's a gap in the chain, guys, I have a chain right here. If there's a gap in the chain, will this hold up on my neck? No, it will fall, right? So the links are very important because that's what connects the ownership and the right to claim the property, right? That's what connects and gives the right to transfer, the right to claim, and so on. So links. All right, so Zenaida mentioned something on YouTube. Hold on, talking about adverse possession. Zenaida says, I did it. The property was empty, and the tax was for sale. So Lee, you wanted to know? Zenaida is telling you the trick right now. The tax was for sale. I bought it and became the lien holder. I jumped into the house and bought the property 3 years later. She did not wait the 20 years. She found the loophole. Buy the taxes. Right? So the tax foreclosure. We'll talk about it when we get to taxation, but you buy the tax foreclosure. And that's depending on the states. State of New Jersey is a 2-year waiting period. So after 2 years, if nobody pays the tax lien, you foreclose on a tax lien. Property is yours. Okay? So tonight, if you don't mind me asking, just ballpark, how much did the whole process cost you? between purchasing the taxes, moving into the house, filing to get the property, the foreclosure, and all that stuff? Lee's already like, is there a site? Let me go get some properties. Yeah, you go to google.com, and until 3 years ago, we did not have this, but now we do. You go to google.com and you're gonna type, don't go yet, relax. They're already gonna search properties while in class. And you're gonna write New Jersey, tax, foreclosure, sales. I'm gonna give you another neat trick. Ready? The foreclosure site doesn't sell only foreclosures. Taxes. They also auction water liens and sewer liens. So instead of a $15,000 tax that you're bidding on, you could be bidding on a $1,000 water bill. Same. And the rights are the same. Anyway, we'll talk better about that at a different time. Zenaida says she paid $58,000 on the lien. Zenaida, if you don't mind me asking also, what is the value of the property? More or less. You pay $58,000 on the tax lien. And 3 years later, claims the property. Okay. And how much is the property worth? By the way, that was an expensive foreclosure. Something must have happened there. I'll give you guys the numbers in a second. She's just writing on YouTube. It took 3 years to foreclose. Okay, so let's look at the numbers. $58,000 on the tax lien. I don't know what happened with a foreclosure, but $129,000 in foreclosure, right? So we are at 190, less than $200,000 paid, less than $200,000 out of pocket. The property is valued at $400,000. She just doubled her money. You guys got it? Not that bad, right? So, go back to where we were. That's a great success story, Zenaida. Thank you. Recording system, title evidence, and all that stuff. State laws require the recording of all documents, and they determine where it's actually recorded, where it's located. Each state has different laws regarding where, if it's county records or anything like that. State of New Jersey, for instance, they have county records, but then certain counties have their own registrar separate from the town, from the county. We need to move on from matter of possession and tax liens, but Lee, what would be the reason you can't claim? Because you got paid. We'll talk about tax liens in a later chapter, but because you're foreclosing on, as Tonight's example was $60,000 tax lien, 58, right? Because you're foreclosing on that. If there's a mortgage lien of $300,000, do you think the bank is going to let go of $300,000 because you bought a $60,000 lien? The bank's going to fight you. And it'll get to a point where the bank pays you to walk away. So it's a win-win situation. Actually, win-win-win. You either win because you get the property, or you win because the homeowner pays you, or you win because the bank pays you. Somebody's going to pay. So with interest. State of New Jersey and Florida and a few other states, the statutory interest is 18% on these liens. So somebody's going to pay. Yep. Now, can we move forward? Great. So back to where we were. Deeds, mortgages, liens, easements, and sales contracts are among the documents that must be recorded. Other public records that affect real estate are marriage, probate, and tax records. So, marriage, probate, and tax records. Do you think these are recorded in public records, like the property public records? Are these recorded there? And the answer is no. And the answer is no. So, deeds, mortgage, liens, easements, sales contracts, these are all recorded against the property. A marriage is not recorded against the property. It's a civil union, right? So we'll have that in civil records, something like that. Probate, the same thing. And tax records, it's the municipality's records. So these don't have to be recorded, but they're still enforceable. Generally, a county recorder's office or other similar named office maintains the title records. And the title records serve a number of purposes, not the least of which is to avoid ownership disputes. Other important purposes are public notice. We talked about this earlier. Constructive notice. It's there. It's available. The public, the general public, can get to it. Look, taxes are public. I can find out how much you pay in taxes on your property. It's easy search. The deed, I told you I can find out. The mortgage, I can find out who you have the mortgage with. Who do you owe money to and how much? I can find all that, not the balance of it, but the total amount at the time. And then we can use something called calculated guesses to figure out if there's equity or not in the property. But I can find all this stuff out from public records. It's available. Okay? It doesn't show, by the way, you can relax. It doesn't show your social or date of birth or anything like that. It's not there. It shows your full name that's on the records. It shows the property address. It shows your mailing address if on the mortgage, right? So it's one of the things that I can tell you right now, it scares me in this country, is we're so worried about security, right? Identity theft and all that stuff. Yet, almost all the pieces can be taken out of public records. Almost all the pieces. Like, there's a lawsuit. You can go online and figure out if you have a small claims lawsuit against you, if you have an eviction against you, if you have anything, you can pull it online. And then there's other sites, they give you part of the information, then another site give you the other part of information. You put it all together, and boom. I become you, and I sell your information, or I get credit cards under your name, or I get loans under your name, and so on. Or sell property, right? Sell property that I do not own. Remember, I was selling you the mouse? Not mine. I'm selling it as if it was. So it's scary how public records work, and you guys should be very careful always in what's disclosed in public records. So now there goes the corporation, there goes the trusts. These are great ways of protecting your info. Okay? Great ways to protecting your info. Corporations, trusts, especially trusts. Buyer protection. Title records protect the buyer by revealing whether the property has marketable title, one free of undesirable encumbrances. Okay? So the reason why we pull title searches, as we said before, is because we want to see what's on record. What do you owe? What will I have to pay for it? Like, let me make sure that I'm getting the property free and clear of any issues. Right? So you have to have what's called marketable title. Okay? Marketable title. So let's talk about the word marketable. I want you guys to write in the chat. What does marketable mean? What does it mean to be marketable? Forget the word title, just the word marketable. What does that mean? Marketable. Marketable. Let's see right here what we got. Sellable, the way you sell it, to advertise, to be able to sell easily. Sellable, sellable, something that is sellable, something that you would like to sell. So, not bad. Marketable is something that you can trade either by selling or gifting, yes, on the open market. So marketable is something that could be transferred from one person to another. It could be personal property, it could be real property, but it's something that could be transferable, sold or gifted. Very good. So let's go here real quick. And I'm going to ask you a few questions to see if you understand the different types of buyers that we have on an open market. I have a question. Who goes to the supermarket? Raise your hand if you go to the supermarket still. The reason why I'm asking is some people now order online, okay? You can put your head down, that's fine. Now, the second question is, if you go to the supermarket, and I always give the same example, I've been doing it for 3 years, this particular example, and it's been effective in most of the classes, so hopefully it'll be in yours as well. If you go to the supermarket, let's say you want to buy milk, right? And some of you are probably like, oh, milk, really? Who still buys milk? Well, let's say you buy milk. You're going to look at what your favorite milk is. Like, let's say the percentage of the milk is like 2%, like 1%, 2%, whole milk, whatever. You are looking at the 2% milk as an example. What is the next thing you're going to look at? You already found the brand. You found your 2% milk. What is the next thing that you're going to look at when you're looking at milk? When you want to buy milk. Okay. Benjamin says price. Celine says date. What else? Romello says, Amy says date of expiration. Date, price, expiration date, expiration date. What else? Anybody else? Make sure there's no leaks or damages to the bottle. Okay. That was a good one. It's the first time I see that one, but good one. What was the first thing that you mentioned? My name is Bruno, and this is a real estate class, New Direction School. First thing that I mentioned when. What I was saying is that you found it 2%. You found your, whatever the milk was, right? And my question is, what is the first thing you're going to look at after that? You already found the bottle that you want. What is the next thing you're going to look at? So the whole price thing, out the door. You already found the one you wanted. Expiration date. Okay. All right. So now some of you are going to get grossed out by what I'm about to say, but there's a point to this. Milk, Elda, and everybody else that answered this, milk does not expire. The bottle or the carton says sell by date. So if you want to consume it as milk, they're saying by this date it should have been sold. It might last another day or two as milk, right? And the reason why I'm asking this is because after milk expires, meaning it's not drinkable as or used as milk anymore, what can we do with that milk? Does anybody know? What can we do with the expired milk, as you guys call it? Cheese. Okay. Yep. What else? Yogurt. Yep. Anything else? There's a lot of things we can do with milk. So let's stick to cheese and yogurt. That's fine. So most people throw away the milk after that date. You guys know that? Most people want the milk to be drinkable. They don't care about cheese or yogurt. For that, I'll buy it already made, right? Turnkey. I don't have to have all the work. So cheese, yogurt, we buy it ready made. Here's the point. When you go buy a house, and I'm going to go to this one because it's the first time I had this and it was very good. When you go buy a house, Do you want to buy a house that has leaks or damages? No. Most people, 99% of the people, want to buy a house that's turnkey, that's usable as a house right away. Some people are willing to deal with the rotten milk, the expired milk, and make yogurt and cheese out of it and profit. When you look at a house, most people want the house ready to go. Investors, we look at a house that has problems. We want the problems. Okay? So when we talk about marketable title, that's what we're addressing. We're addressing whether it's sellable as is and people don't have to worry about it. Sorry. I'm in Newark, so you're going to hear this a lot. And right on 21, so it's easy access to 1 and 9. It's easy access to everything here. It's unbelievable. But then again, I have almost 24,000 cars that pass in front of this location every day. So I'll deal with the sound in exchange for the exposure. All right, so again, there's a lot of people that want to buy the property as is, and then there's people that are willing to take all the problems with it. Marketable means tradable, subject to whatever the buyer is willing to do. So that's what we just went over. So there shouldn't be any issues with the title. There shouldn't be any issues with the property. Marketable. Okay? Any questions here? Felix and Nina, I'm waiting for your next book. Let me know. All right, the next thing we have is lien holder protection. When we check the title, oh, by the way, here if you want, you can write in front of marketable title or buyer protection, write rotten milk, so you remember this story and the analogy. Okay, it might be helpful. Marketable title, drinkable milk, or rotten milk. Okay, so the answer in the state exam or school exam is it's free of any issues or free of any claims other than those that the buyer is willing to accept. That's pretty much what it is. So marketable is free of any issues other than those that I want. So tradable, sellable as it is, without any issues, unless the buyer accepted some of them. Okay. Lien holder protection. So lien holder, for instance, the bank, whoever you owe money to. Pulling title records protects the lien holder or the lender or the bank, whatever you want to call it, by putting a public notice that the lien exists, right? The reason why we file a mortgage on record is to let the world know as well. We talked about this yesterday, that there's the deed, which is a title, and then there's a mortgage that says the bank is first after taxes or superior liens, right? But the bank is first. Whoever comes and records after is secondary or junior lien. You guys remember this, right? So it protects the lien holder, that they have a position in the event of foreclosure. When we were talking about chain of title, this refers to the succession of property owners of recording dating back to the original party. I covered all this. If the chain is broken, if there's a gap in the chain, then we have what's called a clouded title. So it's encumbered, if you guys remember these words. Clouded or encumbered means the same. Clouded title. And if you want to clear the cloud on the title, you have to file a suit to quiet title. A lawsuit to relieve these encumbrances from the property. Okay? That's what it's called. To pull records, one of the things we do is get an abstract of title. Now, the word abstract is what you need to identify when you look at the question or the answers. The word abstract means a brief history or summary of everything that's on record. See, an abstract doesn't mean I have the physical document. An abstract says, on this date, this was recorded. On that date, this was recorded. The following date, this was recorded. So it puts in chronological order all the events that went against the property. So both the recording or the releasing of any claims. Okay? So everything is going to be given to you in chronological order when you do a title search. So, state exam, school exam, if you see summary, if you see abstract, if you see brief history, they all mean the same. And that's how you associate to answer that particular question. Okay? Torrens system, like I told you, certain states and counties use it, and the majority of them don't. The Torrens system is the one where you have a certificate of title where everything is recorded against the certificate, registered and recorded against the certificate, like your car. It has a title, doesn't have a deed, doesn't have a bill of sale. It's a title on one side, bill of sale on the other. They're all one document. So the deed and the title become one document. Okay? Similar to the car. All right. Title evidence. How can we prove we have a good title? Anybody? How can we prove that we have good title? Let me know in the chat. What would be considered title evidence? Caleb says insurance. Okay, what, title insurance? Is that what you're saying? Elda, you don't have to write your name first every time. It shows me your name. I got you. Elda says paper, even though your camera is off again. I'm going to fire you, Elda. That's what I'm going to do. Zaline says to be delivered and accepted. That doesn't prove title at all. But it proves that the transfer occurred. So that was a good thing. Anybody else? Poor Romello. Trying to get the class done. I know. Nina says record. Felix says bill of sale. Caleb wrote that. So I was right. It was the insurance. Okay. The night says record. What else? Title evidence. Actual notice? Maybe. Give me an example of actual notice. Making you guys think, huh? What proves or gives evidence of title? The deed. Romello, the deed just proves that a transfer occurred or happened. Okay? Since Cardi, I can never say occurred without thinking about her. It's terrible. Right? Anyway. Anybody else? Deed is not valid. It's just a transfer. Does not prove title. So far, we only have one correct answer, but there's more. There's more options to prove title or to evidence title. So far, we only have one correct answer. Zaline, actual notice and constructive notice go back to the same issue, which is, give me examples. It's perfect because for a title to exist, for evidence to exist, there must be at least constructive notice. And when we pull the title search, we have actual notice, so that's great. But you're still not telling me what proves title. What is evidence of title? I mentioned earlier to you guys already. Okay. Public records, absolutely. Getting stuff from public records, which could be constructive notice or actual notice. Yep. All right. I'm going to help you. Ready? Amy, a deed just says there was a conveyance. Just says there was a transfer, but does not prove me giving you the mouse, that's the deed, does not prove that I had the right to transfer it. Okay? So there's no evidence of title yet. So here we go. Since the value of property is only as good as the marketability of its title, the evidence supporting the status of title is a significant issue. To demonstrate marketable title to a buyer, a seller must show that the title is free of doubts about the identity of the current owner, defects such as erroneous legal description, claims that could affect the value, or undisclosed or unacceptable encumbrances. How do we prove that? There's 4 principal forms of evidence that can support these assurances. For us to prove that none of these exist on the property, right? We have the Torrens certificate we talked about before, the certificate of title, right? We have the title insurance, so congratulations for the correct answer, the one person with correct answer, right? And it's totally fine, we're learning. Attorney's opinion of title and title abstract, right there, title abstract, we saw this word before. And finally, title certificate, which is very similar to a Torrens certificate in terms of naming it. So certificate of title, title certificate. And there's no abstract, just an opinion. The problem with these, in both of these, there's a search of public records. This one, there's no search of public records. No, I know. I gave you, you were the one person that said it right. And I'm glad you changed your name now. Thank you. I know, I got you. Thank you, Jackie. So it says right here, title certificate, like I said, is just an opinion. So we pull all the records and we'll give an opinion, is attorney's opinion of the title abstract. We don't pull records, we just give an opinion, it's a title certificate. Who gives the opinion? Attorneys, usually. Because it's a legal opinion, there could be consequences if the attorney is wrong, much like a medical opinion, right? If a doctor, the professional, says, you have this or you have that, and then turns out you went through treatment for no reason because you didn't have that one thing, right? They could be sued, right? Attorneys, the same thing. If their legal opinion, they are the professionals in the legal manners. If their legal opinion is incorrect, then you could sue the attorney. And both of these, but more in this one, because there's not even a history, not an abstract, okay? All right, so we're gonna go over these. Let's start with Torrens. I'm sorry, with title insurance, I already covered Torrens certificate. The title insurance policy is the most commonly accepted as the best evidence of marketable title. So the best way for you to figure out if a title is marketable is insurance. Okay? It's much like you're going out there on the road. What is the best way you can protect yourself from any claims? By having insurance, right? So, are you a good driver? It doesn't matter. You're insured. In this case, is the title okay? Well, when they verified it, it looked okay. So they insure the title. They guarantee that if anything happens within certain things that they say they were going to cover, they will pay the claim or fight for you, right? So that's insurance. So the title insurance policy identifies the policyholder against losses arising from defects. The standard coverage of these policies protects against title defects like incompetent grantors, invalid deeds, fraudulent transaction documents, and defects in the chain of title. Okay? So what we're saying is these are the basics. If anybody committed fraud, against you, the title company will fight for you, so you don't lose your interest. You are insured. They will pay that claim, or they'll fight for that claim. You guys got it? So title insurance. There's an extended coverage, meaning you can go beyond this, but may not be something that may not be of public record, including fraud and recorded ownership claims, unintentional recording errors, and unrecorded liens. Stuff that was not there, but could still affect the property. All right. So Lee is asking a question. Is there a state that simplifies the title and deed process by combining them into one versus two separate? Actually, these are all separate. You can have one, you can have the other. So these title, for instance, in New Jersey, we do title search. For the majority of the state, we do title search. And the title search then is insured. So you have title insurance for your transaction. Unless it's a rural area where it's very difficult for you to find records of a farm that's been owned by the family, supposedly by the family, for over 200 years. Does that make sense? So if it's more recent transactions, somebody will do the title search, provide it to the title insurance company. Title insurance says, seems to be okay. We will guarantee, or we will insure this. So it's a one document thing. Okay? So when we said all of these, it's one or the other or the other or the other. Okay? Every state has different things. Torrens certificate is not used in New Jersey. The Torrens system is not used in New Jersey, as an example. You got it? So we only have one document to deal with. Now, before issuing the title insurance policy, as I was saying, they conduct a title search to figure out see if there's anything that you're not aware of. Once they do that and they agree, they'll issue a binder or commitment to insure. That's it. The next one was the attorney's opinion of an abstract, right? So it's an attorney that reviews the title search, the abstract, the title search, and the attorney gives his or her legal opinion on it. So because an attorney gave a legal opinion, that's good evidence of title, because you know what? If it's wrong, sue the attorney. Okay? And the title certificate is the same thing, but no actual records. So it does not guarantee or against anything. It just says, hey, go ahead, transfer. It appears to be okay. No commitment, anything like that. No full commitment. Okay. You guys have any questions? Anything you'd like to address? Because we're done with this chapter. Hey, it's 1 o'clock. Not bad. Questions? On security alert. Okay. Which one has more relevance, a deed or a title? They're different. Nina? They're different because a deed, again, just proves that there was a transfer. Does not prove that title actually was there in the first place. So when we do a title search, okay, we do a title search, all it means is we want to know what's on title, meaning what's on record. A title search is to find out the deed, so to find out who the current owner is. Okay. Any liens against the property, so first mortgage, second mortgage, and so on. Unpaid items, list pendants, which is to let you know if there's any lawsuits. So when we're talking about title, we're verifying all of these things. The deed just says it transferred and there's a new owner. Title is all of this. So which one is has more relevance? Well, again, all of them, they're different purposes. You got it? A deed is different from a lien, but they serve the same purpose, which is recording into public records and give notice to the world. The title search will bring all of these items. So a good title is all of this is identified, and the buyer either agrees or disagrees with certain things. That's it. So a good title is we know all the issues against the property. Or not. Like a title search might not show anything other than the deed. Why? Because it's paid off, for instance, or it was bought cash and that's it. There's no other liens against the property. There's no other issues against the property. So it's still a title search. After you have the title search, you have something binding that says, other than the deed, there's no issues. Okay? So basically, Felix is asking, so basically they go hand in hand? Yeah, kind of. Yep. If I pull a title search and the deed is not there, then you are not the owner. So yeah, for it to have a good title, it has to show that there's a deed with your name on it. It has to show a good title. Because if it's somebody else's name, can you sell the property? No. Is there a statutory deed that is better or preferred over the other? So it depends on the states. The most common one to be used is the bargain and sale deed with covenants against grantors acts. So that's the limited or the special warranty deed. Okay, that's the one that's usually used. All it says is, I guarantee while I had the property, this is what I did, and now I'm transferring it to you. Whatever you do is on you. That's the most common deed. Denied, no problem. Thank you. We'll talk. Any other questions, guys? Drop questions. Now's the time. You literally have almost an hour to ask questions. Except that. Go back. What do you mean go back? What do you want to know about abstract? I'll go back to it. But what do you want to know? What's the question? We're getting a 10-page question. I got your question. Okay, so there's a question, and the question is, I can't remember the question right now, which is great. All this to write, I can't remember a question. But I know it was something about the topic above abstract title section. Okay, this is abstract title. Topic above is chain of title, clouded title, and suit to quiet title. See what the question is. Right? While you remember that question, I'm going to address. Jacqueline just send me a question on WhatsApp, which is, how do you recommend studying and retaining all this? That's like the best question ever, right? Nidia is like, yeah, please let me know. What's the secret sauce? Well, if you ever watched a great movie, I think it's like the movie of the century, Kung Fu Panda, there is no secret. Okay? There's no secret sauce, there's no secret anything. Everybody learns in different ways. Some people, Jacqueline, some people just audio is good. Some people is visual. I give as many tools as I can. So you have the Quizlets, which is the flashcards, as you know. I have the quizzes for each chapter at the end, but which is also at the end of the book. We have a practice exam when you get towards the end. You can practice yourself at taking the actual school or state exam. Very similar. So I think it's more about repetition than it is. And when I say repetition, I'm not talking about repeat the same thing over and over. Repetition and consistency in studying and reviewing things. I see a lot of the times you guys have distractions around you, right? A lot of times there's people getting in and out of your room, and yeah, that becomes a little difficult because your mind, even though you're looking at the screen, your mind is now distracted with whoever's next to you. So this happens a lot. And then some of you get in your car and you start driving and you go somewhere and then you come back and whatever. It's difficult for me to say there's one particular way if you find all these distractions over a 4-week period. You see what I'm saying? So you're going to take the exam at the 5th week, right? But if during these 4 weeks you're not paying attention, if you're not studying, if you're not fully focused for only 4 weeks, then there's no recommendation I can give any of you of how to study. Studying has to be a combination of things, but first comes with focus, accountability, making sure you take actions. Okay? Again, use the Quizlets, use the resources, the chapter reviews at the end of the book. Watch the videos again, replay, ask me questions. That's the best way for me to know. By the way, Jacqueline, I did receive yours. I will address them later on. But ask me questions asking questions is probably the best way to study, because as you're going over, for instance, let's say you're going over questions right here. Let's say this question is what you went over. Take a screenshot, send it to me, and say, Bruno, the answer was C. I don't know if it is. I'm just glancing at it. The answer was C. Can you explain why? I did not understand. I thought it was A. And then I'll explain to you why it's C versus A. Does that make sense? So that interaction here in class and after class is very, very important for the majority of the students. Some students can be self-sufficient and they don't need my help at all. The majority of students need it because of your busy lives, because of your learning pattern and so on. And I made myself available. I gave you guys my number. If you don't ask questions, then it's on you. You see my point? The best way to study, you have to find it. I'm here. The tools are available, and we'll go that route. So make sure you ask questions. Okay? And I think I got Nina's question. Okay. Question is, I think I remember encumbrance equals cloud, which is also a lien. Question mark. Okay. So can you sue if there's a lien placed on the property to get the claim removed? A lien is a financial claim. It means there's a mortgage, right? So who are you going to sue? Right? You're going to sue the mortgage company? No, they're the ones that have a claim against you, right? So if you're talking about here, if you were talking about if you're talking about the suit to quiet title, so let's say the reason why this is here, and you can think of the lien about it as far as this is, when you finish paying off your mortgage, right, the mortgage loan, when you finish paying off, the balance is zero. If the balance is zero, then the bank no longer has a claim against your property. So the bank needs to release it from your property. If the bank does not, then you need to take an action to clear it from the title. So yes, you could sue to clear from the title, granted that you are done with that particular debt and it just wasn't removed. The other question is, can an encumbrance be anything besides a lien? Absolutely. It could be an easement. It could be an encroachment. It could be a license. An encumbrance is anything and everything that affects the property value, the property usage. So, shared driveways affects the property usage. Shared party walls affects the property usage. If there's a mortgage on it, it affects the sellability of the property until you clear the mortgage. So we need a marketable title. So encumbrance could be a lien, financial claim against the property, or any physical or usage encumbrance. So people that have rights to use your property for whatever reason. Those are all encumbrances. Not all encumbrances are liens, but all liens are an encumbrance. Okay? Next question. Any other questions? Olga, I saw your message. I'll address it in a second, okay? Nina says, I'm done. Okay. I appreciate you, Nina, because I always have one person that asks a bunch of questions, and that's great. That's been you and Felix. I appreciate that. I had one class in, see, you and Felix, and Felix just asked a question. I had one class where I had one person, Daphne. She asked questions for the whole 33 or 34 people we had in the class, right? Every 2 seconds. But Bruno, and I'm like, whoa, hold on. Okay, I need to move forward, right? But it was a very good class because all her questions helped the majority of the class actually pass. So the more you guys ask questions, the easier it is, because the question you have in your mind could be the question the other 15, 20 people have. So always ask a question. So does encumbrance have different meanings? No. There's just different types of encumbrances. Okay? Right? Let me ask you, does weather have different meanings? No, there's just different types of weathers. It could be sunny, it could be rainy, it could be snowing, right? So encumbrance simply means something attached to the property that limits the property. That's what an encumbrance is. It's a cloud on the property. It limits the usage of the property, sellability of the property. That's an encumbrance. It could be the fact that you're sharing something with your neighbor. It could be the fact that there's a loan that's attached to the property called mortgage, right? So it could be anything attached to the property. An encumbrance, easement by prescription, somebody that's squatting on your property, trying to take over. It's an encumbrance on your property. So any of these things could be an encumbrance, right? There's not different meanings, it's just different types of encumbrances. Okay? Can you change the meaning of season? No. There's 4 seasons, but season is a season. You got it, Felix? Cool. All right, so let me address Olga real quick. Olga asked me how to get into the student portal. So if you go, when you registered, guys, here. So you were here, right, Olga? Main page. So when you register, guys, great. You're gonna click. If you registered, then he gave you an option to create a student portal access. But you go here to where it says student login, click on it. Go. And it takes you to your student portal. So if you have never logged in, then it asks you for your email and it asks you for the password you created. Okay? If not, then Olga, the link that I sent you before, it goes straight to the registration of the student portal for you to create a login for your student portal. Okay? Once you see this, so you are on your phone, I recommend you flip your phone. So then you're going to see it exactly as it is here. Otherwise, on mobile, it's going to look like this. And you have to go all the way down. Okay? Okay, scroll down. You are not here yet. Click where it says right above. Click where it says student login. No, you went to courses. I said student login. Look. Let me go back again. Okay. So this is what you have, Olga. I put it on as if it's mobile. You're gonna scroll down, and right here it says student login. Don't click home, don't click courses, don't click anything else but student login. You click on it and it takes you into our student portal. Is anybody with difficulty accessing student portal as well? Let me know. All right, Nina. Let me see again. On the left, click students. Your phone just doesn't want to help. How it is. What is that right there? I can't. Oh, that's for you. That's your login. Go ahead, put your email and your password. If you don't have it, then click right below where it says forgot password. You good? It takes you back there. All right. So, all right, Olga, I'll get on the phone with you after, and we'll figure this out. Okay. All right. Okay. Or when the Zoom is done, I'll just log into your. I'll give you access to show you on your screen. So Nina has a question. Go back to this. I thought you were done. Didn't you say like I'm done? All right, so row homes and townhomes have an encumbrance because of party walls. Bingo. Yep. The party wall is an encumbrance. It's shared wall that separates the parties, and because you are obligated to maintain the other side, your side of the wall for support of theirs, is an encumbrance. Yep. Very good. Felix, if I want to take Quizlets according to the chapters, how do I go about it? Well, right now we're doing which chapter? Felix, which chapter are we doing right now? You're going to go here, click on Nationwide, because that's where we are right now. We're in the Nationwide portion. And you're going to go to the chapter that we're handling right now. Right? This is the chapter that we're in right now. Click on it. And boom. Everything is here that we just went over. Boom. Okay. Transferring and recording title to real estate. Okay. You want me to start all over? Okay, chapter 1. You want me to show you the Quizlet again? That's what it is. So when you click on the Quizlet on the student portal, so let's go here. Access course resources. If you are on your phone, you have to scroll all the way down and things are here. Or you can flip it sideways and it gets right there on the side. you're going to look for Quizlet, click on it, takes you right into this one, and then you go to the nationwide portion of it, and you search for the chapter that we're addressing, which is transferring and recording title to real estate. Okay. Fallon, I received your message. Can you write there what's your on the WhatsApp? Write your Quizlet username. Okay, so there's a screen name there on Quizlet. If you cannot access, just write it, and I'll add you manually to give you access to it. Okay. Felix has another question. I can also get all the chapters are there, so you can get to every single chapter except the first one, which was simply an intro to the book and to the real estate business. So that one's not there. But all the other chapters, estates and interests are there, legal descriptions are there, contracts are there. Everything is there. Okay. Will the first chapter be on the exam? Well, the first chapter is then mixed into the other chapters. So it was, like I said, it was just an intro. So parts of that chapter are scattered throughout the other chapters. So yes, you will be there. Right. So I'd still review it, and I'll still go through the questions, because sometimes one chapter explains one thing better in that chapter than later on in another chapter. And by the way, that is true also for the exam. Both the school exam and the state exam have similar questions at different points of the exam. So let's say your question number 2 could be very similar to question number 30. And sometimes one explains the question better, or the answer is better than the other one. So you can use one to fix the other. In the book, same thing. Sometimes chapter 2 mentions briefly, like we talked about adverse possession 10 times already, right? But I think in certain chapters, it's clearer what adverse possession would be than in other chapters, as an example. Okay. All right, guys. If there's no other questions, we will end for today. It's 1:30. Fallon, I just added you, so see if you receive it. Again, I was looking for the screen name, not the email, but we'll go with the email. Hopefully you get it this time. Okay. It tells me there to put either screen name or your email. Is there anybody that still does not have access to Quizlet? Okay. Jacqueline, make sure you register with Quizlet.com. If you have an account, let me know your username and or screen name or email that's registered, and I'll send the link to you. Okay. And again, Olga, I'll address you a little bit right after class. We're good? All right, guys, if there's no other questions, then we will end the class for now. And I'll see you later if you're joining the evening class, or I'll see you tomorrow at 10 o'clock in the morning for tomorrow's class. All right, guys, enjoy the rest of your day, and thank you.